if we are to thank Hollywood at all, I think it is to thank Hollywood for putting a focus on an issue that many of us have been dealing with for years. We're going to talk about a couple personal reflections and then Hollywood framing the current discussion, refresher of the basic law and guidelines governing sexual discrimination and harassment. The third, the blurry lines between civil and criminal areas. 4, other types of harassments that continue to affect us in the workplace. 5, recent new gender-based concerns that have emerged. And 6, our conclusion. So let us move on to Hollywood framing the current discussion. The takeaway for me, at least, is that there is a continuing need to train in all of our workplaces about harassment and discrimination against any and all protected classes. I've always had some concern in the past when a seminar has emphasized sexual harassment, that folks think that only sexual harassment and discrimination is the problem, whereas discrimination and harassment involving membership in any protected class is and remains a real problem for legally protected classes. As a personal reflection, it's been interesting in the past couple weeks to see all the Me Too's who have come forward in Hollywood. And actually, it kind of surprises me. The casting couch, I think, has been a legendary concern for folks, but sexual harassment is, in my estimation, pandemic in other workplaces as well. There was a relatively recent NBC poll with the Wall Street Journal, which indicated that 48% of women believe that they have been sexually harassed at work. And again, on top of that type of harassment, I think we would have additional harassment against other protected classes. For me, the real surprise is that this topic is now being taken very seriously and that the ramifications for the alleged offenders are real. For years, those of us dealing with human resources have been talking about appropriate consequences for the perpetrators of harassment, but now we're actually seeing some of those in terms of loss of positions, in terms of halting of filming, in terms of loss of publicists, which have to be very important folks for actors, and in terms of announcement of rehabilitation for some of the folks that have been alleged to have been perpetrators. To me also, there's a bit of irony. Robin Wright, who's the actress who plays or played, and I'm not sure which verb is appropriate at this point, she was the actress playing Claire Underwood in House of Cards. She demanded at the beginning and received equal pay with her male co-star per episode after she threatened to go public with the differential. To me, it's very interesting that she may be caught up in something if the series is canceled, where it would also impact her. And of course, that was not sexual harassment. It was just straight sexual discrimination and would be in our workplaces actionable under the Equal Pay Act. But it's about time, in my estimation, that the 1964 protections of Title VII are implemented in all of our workplace settings, not just in Hollywood. Interestingly enough, union leadership has been taking action. As the management side labor and employment attorney, you can imagine that I don't often concur with or quote union pronouncements, but a recent one at the beginning of the AFL-CIO convention caught my attention. The quote was that the recent news regarding sexual harassment in numerous industries has shown us that no organization, including our own, is immune to a culture that has allowed both women and men to feel unsafe and threatened on the job. And that quote is in a statement that was written by President Trumka of the AFL-CIO, his secretary-treasurer, Liz Schuler, and the executive vice president of the organization as well. And that's the way they opened their recent AFL-CIO convention. So clearly this topic is one that folks are looking at in this day and age. I will share with you that there was a time when I began the practice of law that I thought by the time my daughters were grown that sexual harassment would not be in the workplace. Well, my daughters are now grown, and unfortunately we still deal with multiple types of harassment and discrimination in the workplace. However, hope springs eternal, and I hope that at some point we can at least dramatically reduce the types of harassment and discrimination that are out there. So with that, let's go into a refresher, because the basic law and guidelines governing sexual discrimination and harassment remain unchanged. The application is what we're seeing that is different. There is an unlawful practice under both federal and most state laws. Title VII, of course, is the mainstay under federal law, which provides that to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin or ancestry is prohibited. On top of that mainstay federally under Title VII, there are new laws that have made it inappropriate to discriminate based on disability under the Americans with Disabilities Act federally, as amended, under the Age Discrimination in Employment Act, and under the Genetic Information Non-Discrimination Act. Many states have state laws that parallel Title VII. In Pennsylvania, for example, we're talking about the Pennsylvania Human Relations Act. In New York, you could be talking about the New York Anti-Discrimination Act, and most other states have a similar act, although not all states. So in some cases, you have the potential for actions under both state law and federal law based on the same occurrence. As a refresher on protected classes, we should remember that federally, age at 40 or older is guaranteed non-discrimination. Race and color are federally protected classes. National origin, that is where you were born, is protected. Ancestry, as in where your ancestors came from, is also protected. So, for example, although my origin is US, Ancestry.com tells me that my ancestry is basically Irish and English and, interestingly enough, Scandinavian. Sex, gender, including pregnancy, falls within a federally protected class, as does both religion and creed. There are, however, more protected classes: mental or physical disability under the Americans with Disabilities Act. We talked a little bit about the Genetic Information Act. There's one that I call a quasi-protected class, which is union or protected concerted activity, so that although it does not show up in the general laundry list of protected classes within Title VII, your National Labor Relations Act will protect that union or protected concerted activity, and in many states those will also be protected. And we have an increasing number of protections in law for whistleblowers or users of statutory rights. In some localities or states, you will have more, or you will have even more protections. Marital status, for example, in some locations can be protected, although sometimes that's broken down as head of household or anti-nepotism rather than gender per se. It gets us into what is sometimes referred to as gender plus discrimination. Sexual orientation, preference, identity, or various other ways of saying that may be protected also in certain states or localities. We are now getting into vocabulary, frankly, that I've never seen before the past year in terms of non-binary existence or pansexual existence. So these are areas that may be protected under specific local ordinances as well as under some state protections. The EEOC statistics show that sexual harassment charges slightly declined since 2014, which is kind of interesting, in that there were almost 7,000 charges in 2014, and it was down by approximately 100 by the time we got to 2016. Not a huge decline, but a bit of a decline. Interestingly, though, the money associated with the charges has increased from 2014, when $35 million was recovered for complainants or charging parties, and 2016, when $41 million was recovered for charging parties by the EEOC. So that's basically the background with which we're dealing. There are, however, blurry lines which exist between the civil and criminal worlds, and I want to talk today predominantly about civil sexual harassment. We start, and I reference not only the EEOC guidelines, but in Pennsylvania, the Pennsylvania Human Relations Commission has adopted similar guidelines that define sexual harassment to include unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. And then we get a little bit more detailed. I want to stop, however, and emphasize to you that what we're talking about with sexual harassment is something that is unwelcome. So in the instances that we have been hearing about situations in which persons in power apparently were alleged to have taken advantage of folks in lesser positions within perhaps the acting community, and it often happens in other communities as well. But we must remember that if for some reason the sexual advance, the request for favors, or other verbal or physical conduct of a sexual nature is welcome, then you are not dealing with sexual harassment. At the get-go, it has to be unwelcome in order to fall within the EEOC guidelines as sexual harassment. And then the EEOC talks about where the submission is either a term or condition of the individual's employment or basis for employment decisions, and where such conduct has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. In my practice, I've often heard people say that they have been subjected to a hostile working environment. And when you dig down into it, you sometimes find out that what they believe is a hostile working environment is not based in a protected class, but rather is based in a personality controversy between two people. Here we're talking about something that is based in a hostile working environment based in a protected class, and specifically for purposes of sexual harassment based in sex or gender. The guidelines also indicate that sexual harassment can be between fellow employees, and that an employer is responsible for sexual harassment in the workplace where the employee or its agents or supervisory employees know or should have known of the conduct, unless it can be shown that the employer took immediate and appropriate corrective action. So a hostile working environment, a sexual advance by a coworker is often judged differently than a sexual advance or hostile working environment created by a supervisor, because the employer basically is on the hook for actions of supervisory employees if it knew or should have known that something inappropriate was happening in the workplace. An employer may also be responsible for the acts of non-employees. So if a vendor comes in to a workplace and that vendor starts harassing employees within that workplace on the basis of something sexual, then the employer who knew or should have known could also be responsible for that particular situation if they do not take immediate or appropriate corrective action. What is appropriate is going to vary on a case-by-case situation. So generally, discrimination can apply to discrimination or harassment can apply to employees, to visitors, to vendors, to third parties on a site, on a workplace location. The guidelines also say, toward the end of the guidelines, that prevention is the best tool for the elimination of sexual harassment. And I would submit to you that one of the reasons for continuing to train on sexual harassment matters and any type of harassment based in a protected class is an attempt to prevent this type of workplace irritant from happening. And I mean, it's more than an irritant to people who are severely harassed, but it is at least an irritant to people who are observing this type of harassment. So affirmatively raising the subject and expressing strong disapproval, developing policies and appropriate sanctions, informing employees of their rights, and developing methods to sensitize all concerned is really important. And I think that's what we hope to accomplish with today's session. And hopefully you will go back into your workplaces and do even more prevention. Initially, there were two types of sexual harassment which we talked about. One was the quid pro quo, which is simply Latin for this, for that. It is your classic sexual harassment in which sexual favors were traded for some sort of favorable employment action. And in many situations, folks believed, employees or applicants believed, that they could not become an employee unless they submitted to such sexual favors. And then there was the hostile environment, which is more complicated and could include a number of things. It could include jokes, it could include offensive emails, it could include items that are left in the workplace that are most inappropriate for the workplace setting. So any of these could be the stuff of which a hostile environment was made, and often actions would also be included in that category as well. Previous principles apply to other protected classes as well, so you could substitute basically for sexual harassment, harassment based on race, harassment based on religion, harassment based on any of the other protected classes. And I think, again, that's most important that we remember that. Hostile environment claims are going to eventually be determined to be founded or unfounded. Interestingly enough, there was a recent Third Circuit case, which is the circuit that covers Pennsylvania and New Jersey and also the Virgin Islands, in which it was ruled that there was no sexual harassment when a plaintiff was forced to work in proximity to a former harasser. That was not enough that he bumped her arm while she talked to a coworker or stationed himself by the door in a room that both occupied, or that she came face to face with him when exiting a bathroom. It was determined in that particular case, and each of these is going to be a fact-by-fact determination, that the actions were not severe or pervasive enough to constitute a sexual harassment claim. But each of these will be reviewed individually. Sexual discrimination or harassment impacts basically all workers in the workplace, in that sexual harassment can be heterosexual, it can be male on female, it can be female on male, it can be homosexual. As the law developed, it was very clear that men harassing women would pay the price of civil harassment. There was a question until a Supreme Court case known as Uncali of whether or not homosexual harassment was protected, and the court determined in Uncali that male on male homosexual experience was also protected. Transgender and gender identity, I've put a question mark next to at this point, and we'll talk more about the developing areas. The transgender is something that the courts are just starting to look at, as are the various categories of gender identity. And we talked before about including within sexual harassment, not only supervisors, but supervised employees, coworkers, and third parties who might be either vendors or visitors or fall in some other category. Over the years, I've developed a review of sexual harassment cases and concluded that my advice is don't touch in the workplace. Don't touch without the permission of the person being touched, the other person that is involved. And I know of some situations in which folks will go as far as saying to someone who they know is having a particularly bad day or week, I'd like to give you a hug, is that okay? To make sure that it is not unwelcome to the other person. Unfortunately, we simply don't know whether or not the other person has some sort of physical ailment or some sort of emotional situation in which they simply don't even want to be hugged. And there are times when a hug may seem appropriate, but anything involving sexual harassment that also involves touching, I think is much more difficult to deal with than situations in which we're talking about words or emails or texts or things of that sort. So when you see the touchy-feelies that we saw at one time in the workplace often create problems. And I know I've heard some people say, oh, I'm of a such and such a nationality, therefore this is the way I generally do it. The problem is that any type of harassment involves the reaction of the person who has been touched or upon whom the attention has been given, not the person who is doing the touching or giving the attention. So we've got to be aware that our mores, our norms may or may not be similar to those of another employee within the workplace. Common remedies, if it is alleged that there is sexual harassment, first and foremost, we hope that people will feel comfortable going to their HR offices and talking to HR about the situation that is going on. Next, we hope people are comfortable filing with the Equal Employment Opportunity Commission and filing their charge with the Equal Opportunity Commission. The Equal Opportunity Commission has just developed an entirely new portal so that people can do charges online. And if you are not familiar with that, I would suggest that you go on to the EEOC's website and look at the improvements that have been recently made. State agencies will also accept charges. In some cases, there are even local agencies that will accept charges. State agencies generally have work sharing agreements with the Equal Employment Opportunity Commission. So I know of cases in which there have been dual filings where the EEOC has taken the lead. I know of other cases that have been filed where, for example, the Pennsylvania Human Relations Commission has taken the lead. But commonly, folks will go to one of these agencies first because for civil harassment, sexual harassment, it's necessary for an employee to exhaust their administrative remedies before they take it to the courts. And that probably makes sense, otherwise the courts could be inundated with sexual harassment cases. So it's up to the EEOC, it's up to the state agencies to sort out whether or not they believe it is sufficiently severe and pervasive to constitute sexual harassment. However, civil sexual harassment may not be the only remedy, and there are sometimes some blurry lines. Penalties will differ dramatically. If it is criminal harassment of some type, then there is the possibility of incarceration based on the activity that has occurred. And I think in terms of Hollywood, we've heard allegations not only of civil sexual harassment, but we've also heard allegations that go into the criminal area in terms of sexual assaults and rapes. How these charges will be brought will be interesting because some of them at this point are so old and may or may not be past the statute of limitations. So Hollywood's raising allegations of rape and sexual assault. They're raising allegations of rape or sexual assault against a minor by an adult, which may be known as statutory rape in an individual locality. They're raising drug charges. They're raising issues of criminal harassment. They're raising issues of assault and battery and any other related offenses that you can think of under state statutes. And all of those may be criminal on top of the civil. So by and large, the civil remedies I talked about are generally filed within 181 days of the occurrence. Well, as you know, many of the allegations that Hollywood is talking about are really old by either years or decades. So in some of those cases, there may still be statutes of limitations which have not run on the criminal activity, if there in fact was criminal activity, rather than the civil activity. So I think we will see some of these being filed as criminal charges. Some actions may be actionable under both. And again, I've talked about Title VII's 180-day statute of limitations. State agency timeframes are going to vary. So, for example, the combination in Pennsylvania of the state and the federal goes out to 300 days, and there could be civil penalties that would apply in these cases, but in civil harassment, you will not see any incarceration. We should also note that countersuits from alleged perpetrators are possible. And I read an article this morning that indicated that there were concerns regarding the right to terminate certain actors. In Hollywood in the old days, I am told, that it was pretty typical for the studios to include within any individual employment contract a requirement that the person be of good moral character. Over the years, those particular provisions have generally been dropped from the contracts. And it is possible that a contract says that the contract can be terminated by the employer only in the event that the actor is no longer available to work. In such cases, even though the actor had committed sexual harassment, it is possible that the employer, the studio, whoever is actually the employing entity, may actually have to pay out the remainder of a contract to that particular employee in order to meet the contractual terms. So we have to be aware that although sexual harassment is clearly something that violates rights, that there are other contractual rights that may be coming into play. And there have been rumors already that some of these actors that have been alleged to be perpetrators are considering lawsuits against the New York Times, for example, or other entities that could include defamation generally, which is broken down into either libel or slander, depending on whether or not we're talking verbal or written. I think all of this underscores, for those of us that do HR on a routine basis, the need for confidential investigations and not being in a situation where we are circulating partial information before these investigations, especially before these investigations are concluded widely, because we often will not have all the information until the investigation is concluded. And even then, there is the possibility that some of the information has been missed. So keeping this information as confidential as possible is often required, is definitely required. But at the same time, we must be aware that it's awfully hard to investigate sexual harassment allegations if we don't let the alleged perpetrator know the identity of the person who is alleging the harassment. So that's a very, very, very close line. But even if we let that person know for purposes of the investigation, again, we want to make sure that this information is only shared on a need-to-know basis. Sexual harassment requires some sort of tangible employment action. So it could be lack of hiring, it could be firing, it could be failure to promote, it could be reassignment with significantly different responsibilities, it could be impossible working conditions. And again, the courts will generally look at whether or not a reasonable person could continue to act within the setting that they're dealing with, as opposed to someone who has particularly heightened sensitivity. And the decision could cause significant change in benefits. That would also be an actual actionable civil sexual harassment situation, because all of those would be tangible types of employment actions. For sexual harassment purposes, the employer does have some defenses. The first, of course, being that nothing like that ever happened. And sometimes that is what an employer will say or believes. Sometimes the employer knows that the situation did occur, and then they're looking at whether or not the employer promulgated an employment policy and took prompt remedial action. So sexual harassment situations are situations that should be investigated as soon as possible, as soon as the allegations come to you. And I will generally ask that people submit the allegations in writing because of concern that you want to know when you got the document alleging harassment and when you started the investigation. And sometimes it's too easy for someone to say to a supervisor, I've been harassed, and for the supervisor not to realize that that information should be forwarded to the HR office or to management at large. However, the defenses on the policy and the taking of prompt remedial action dissolve if the objectionable action was taken by a supervisor or manager. And here we're back to the fact that the employer knew or the employer should have known that there was a problem. So again, the distinction has to be drawn between employees being harassed for any protected class by a coworker and an employee being harassed by a supervisor or a manager. And I believe in most of the sexual harassment allegations that we're hearing out of Hollywood right now, we're talking about someone who could be considered a supervisor or at least an actor in a higher range on the set. And that will make these allegations difficult to deal with and to understand, because the people feel, the other actors, the lower placed actors, are probably going to feel that it was necessary for them to go along with what the other actor wanted if they were continued to work in the industry. The EEOC has come out with a recent press release in a situation involving sexual harassment that I think is worth noting. Came out in September of this year, in which the spokesman for the EEOC says, simply, federal law grants employees the right to work in an environment free from sex discrimination, including sexual harassment. Gone are the days when a woman on the factory floor must endure lewd comments, propositions of sex, and inappropriate touching in order to earn a paycheck. And in that particular case, there was a significant settlement by the employers that were involved. And that was after a district court proceeding in the federal court for the District of Massachusetts. Today, interestingly enough, the EEOC also released a press release in which they said a particular employer is going to be required to pay $105,000 to settle an EEOC equal pay lawsuit. Again, that would be straight sexual discrimination. But what they found was that female sales reps were paid less than male sales reps in base pay, and they contended that the females were also required to sell more in order to earn the same commissions as male colleagues. So again, on top of the sexual harassment, we often are dealing with situations where there is straight sexual discrimination as well. And again, my mantra, don't forget discrimination and harassment based on other protected classes. We are now dealing in the electronic era in which emails and texts, if electronically stored, create records, timelines, and evidence for cases and are discoverable in litigation. We dealt with one in which a woman alleged sexual harassment, but the emails indicated that she was contacting the alleged perpetrator at strange hours of the morning without any work necessity to do so. And that was something that the courts looked at. I would caution you that although most employers deal with some sort of backup of emails, that we are not always as sophisticated when it comes to texts. So if you are dealing with any situation with employees where you see a possible case like this on the horizon, or if the case has been filed and you know that there are texts involved, you should certainly make some arrangements to secure an app where you can keep the texts that have been sent back and forth, or where you can make scans or pictures of those texts and retain those for purposes of the lawsuits. Electronically stored information is a relatively new frontier in lawsuits, and more emphasis is on keeping that information, and often that will provide you with the timeline with the information that will let you know whether or not there really was sexual harassment involved. So make sure you keep not only your emails, but also have some mechanism to secure text. I know some supervisors are relying more and more on text in terms of disciplining employees. And again, that can become a problem in terms of documentation if those texts are not maintained. I've listed for you a couple other recent examples of sexual discrimination or harassment. There was a parking company who paid to the tune of $275,000 because it rejected female valets. There was a contractor who was ordered to pay $900,000 because of failure to hire and pay discrimination and harassment against females. There was a Great Plains Coca-Cola case in which the company paid $475,000 for rejection of females in non-traditional positions, such as drivers or warehouse or production roles. So again, these sorts of harassment and discrimination are still out there. I'd like to move to a couple examples of other types of harassment that continue. Again, we're including racial, religious discrimination, or harassment. We're talking about national origin, we're talking about disability, and we're talking about age. In 2015, there was an incident which garnered a lot of attention growing out of a Lowe's in Virginia, in which the customer asked for delivery only by a white driver, and 3 supervisors approved that request. Corporate said that we have no tolerance for discrimination of any kind and fired all the supervisors. So there was a prompt investigation and prompt immediate action in that particular case. Religious harassment continues. The case that I've chosen to talk with you about is that one in which the employer was actually pushing its own brand of religion, and they adhered to the tenets of the onion head. The EEOC filed suit against United Healthcare Programs and said that workplace pressure had been applied to have employees conform to the employer's spiritual beliefs, and that in itself violated federal law. And the suit was filed in the Eastern District of New York as late as 2016. So we are still seeing other types of discrimination out there, and there are lots of others. I just use those as examples. Recently, there have been new sexual as in gender-based issues that have emerged. Many people have heard of I Am Caitlin. Transgendered persons would fall within that category, of course. Pregnancy protections are another hotly litigated area. $75,000 was paid to an employee by a United Bible Fellowship Ministries in Houston, Texas, because that ministry had a no pregnancy in the workplace policy, which the EEOC did not approve of. The EEOC has developed a new brochure, and I've shared with you the cover on it because I believe it is different than we are used to seeing. I am still waiting for new signs to be developed and old signs to be removed for restroom areas where we have traditionally had the male and female restrooms. But you can see that we have a combination on the EEOC's brochure of male and female, and then you can see kind of the mix and match that the EEOC has done. The EEOC clearly is accepting cases in the transgender area, although some courts are not as sure whether or not they are extending protections at this point in time. That is an area that I believe you should watch closely, because I believe within the next couple of years it's going to be changing dramatically with court decisions. Pregnancy includes current pregnancy, past pregnancy, potential or intended pregnancy, and medical conditions related to pregnancy, according to the EEOC. And in Young versus UPS, United Parcel Systems, there was a remand to determine if a reasonable accommodation was required for a pregnant employee who could not perform all job functions. Reasonable accommodations might include redistribution of marginal functions, might include modification of workplace policies or equipment, modified work schedules, possibility of light duty, and this is an area that is clearly garnering more attention. So do not make the mistake of saying, oh, a pregnancy is not going to be protected under the ADAAA, therefore I do not have to consider reasonable accommodation. Do consider reasonable accommodations if a request is made. There is, of course, the amendment to the Federal Fair Labor Standards Act, normally wage and hour, added by Obamacare, which applies to employers with more than 10 employees. Exemptions are possible if you go through certain hoops. If you are an employer with less than 50 employees, it requires a private location, not a bathroom, to be utilized by an employer who is breastfeeding a new child, I believe for the first year. And this allows the employee to go into a private area and pump breast milk so that it is available for the child. I would also share with you that language is also key to situations that could otherwise be viewed as sexually harassing. I ask that you make sure that people only use appropriate language to deal with any protected class. We're seeing way too many situations where employees still use language that is considered to be most inappropriate in the workplace. Some will claim that it's okay, the other employee doesn't care if they use it. The problem there can be that other employees who overhear the conversations may care, and it's just simply inappropriate for the workplace. There was a $12 million sexual harassment verdict in a case for call center workers, which included use of language such as I've described on the slide. That does not mean that was the only thing going on in that case, but I would submit to you that it provides a underlay or a foundation for the court to believe that other things were more likely to have happened if, in fact, that type of language was commonplace in that workplace. Coming up to almost the end of our webinar, I would share with you some recommendations for supervisors and managers, and definitely those of you involved in HR. I would remind you that you are often the role model in the workplace, and your liability as a member of management or a supervisor is going to be greater. I would remind you to review your policy and make sure that there are 2 reporting options so that the person does not have to report the alleged harassment to the alleged perpetrator. So at least 2 reporting options. I would ask that you continue training using a real person rather than online courses, and train supervisors and employees separately so that you can make your supervisors understand the significance and the potential for individual liability against the supervisor in some situations. I would ask that you take every report of discrimination or harassment based in a protected class seriously. And if it is not based in a protected class, that you explain to the employee the difference, because unfortunately, wording like hostile environment has made its way into the workplace and is often used in a lay, not a legal context. I ask that you investigate and report in writing or email any harassment to HR as soon as possible, because you folks will understand far more about what is needed than some of your supervisors will. I ask that you respect confidentiality, but don't promise non-disclosure, because you need to disclose some things to some persons in order to run a sound investigation. I ask that you resolve the issue, even if it's he said, she said. And if the resolution is that you don't know the answer, that you at least state that so that people know that you have thoroughly investigated. I ask that you avoid retaliation against persons reporting harassment or discrimination, because that's going to constitute a separate actionable situation in many cases. And I ask that you implement appropriate, and I emphasize the word appropriate, discipline against the perpetrator up to and including termination if you find that, in fact, sexual harassment or harassment based in any protected class did actually occur. In conclusion, I want to share with you the title of a publication which was put out years ago by the Pennsylvania Human Relations Commission. And I think the events in Hollywood have made it clear that the PHRC had a handle on something far in advance of many other folks. The PHRC at that point in time, several decades ago, indicated it's not about sex, it's about power. And I think the type of allegations that we have been hearing recently show that there were many power trips involved that led to alleged sexually harassing activity. I ask that we use Hollywood as an opportunity, as I said in the title, as their luster in Tinseltown dulls, to go back into our own workplaces and spruce them up, because I think it would be unusual to find workplaces free of any type of discrimination or harassment. And I thank you very much for your attention and ask if there are any questions. I'm not seeing questions on my chat screen. Again, thank you very much for your attention, and Lauren will be providing you with additional information.
Thank you very much, Kathy, for that presentation.